range in the sentencing for proportionality. Some states have no minimum age. 60% of this cohort of people, I don't want to call them children because more than 2/3 of them are no longer children. Do you know what I mean? Of the 2,200. They were sentenced as children, but they're no longer children, so I'm not going to call them children. But 60% of them were convicted for the first time. In my state, in Illinois, we have quite a large coalition. There are 104 such people in prison in Illinois with this sentence. And we've set out to interview them. We've interviewed more than half of them, and we're finishing the interviews with the other half. We have a massive database about them, and we're hoping to have a strategy to abolish this sentence in Illinois. I'm not going to go through the other data on this, but secondly, on the life without possibility of parole, we could talk about it if you're interested in it, but because Kentucky manages to be in the vanguard of states here, I won't linger on this. But second, the reasoning, the logic, and the language of the Simmons, Roper versus Simmons case provides us, I think, with very powerful tools to implement campaigns to challenge the trial of children in adult court. You all probably know, if you're students here, that starting in the late 80s, the notion of the juvenile superpredator, the panic about juvenile crime, led to a series of changed laws in 49 of the 50 states across the country, and much more severe federal laws. The notion that our children were our gravest danger, that we had to look at children, or at least certain children, as the threat to American safety at the moment of the end of the Cold War, really strikes me, looking back, as a very strange and unpredictable development. The United States suddenly, for the first time in 50 years, has no external enemy, and who becomes kind of the target and the locus of fear and pandemonium in the United States? It's our children. And so a series of developments happen, which you all, as students here, grew up with, right? Zero tolerance policies in schools, the turning of our schools into mini prisons where you can't get in and you can't get out, the arresting of children in school for behavior that was never before criminalized, kind of extended the whole way. But one of the developments was to make it much easier to try children who are charged with delinquency offenses as adults in adult criminal court. That has incredible consequences, and I think the reasoning and language of Roper allows us to challenge it. There's about 500,000 children tried in adult criminal court every year in the United States today, 250,000. This places them outside of the protections of a separate special court for children. It exposes them most seriously to mandatory sentencing, where the judge has no ability, or the jury, to take into account their age, their role in the crime, or their culpability. So as a result of this, we refer to this whole process, this whole 15-year kind of pandemonium of demonizing young people as a period of the criminalization of youth. Now, in fact, to be academically scrupulous here, I will say that it was in part triggered by a tripling of the juvenile homicide rate between 1986 and 1992. And that was ominous. That was really the only place where there was a jump in serious juvenile crime. The rest of juvenile crime remained more or less stable throughout this period. And that homicide jump led to a nightly series of sensational media stories promoting fears of juvenile offenders. But Franklin Zimring, my colleague in law school and now criminologist at Boalt School of Law, showed quite conclusively that the homicide rate during that period of time was entirely related to the greater accessibility of handguns for children, and that if you took out the handgun deaths, the juvenile homicide rate in that period of time also remained flat and steady. And so one wants to ask, what are we doing about the availability of handguns to our children? There's 3 ways to try kids in adult court. I won't go into the details of it, but 23 states have no minimum age for trying a kid in juvenile court. And really what's happened is that states have either given total discretion about deciding whether a youngster is tried an adult in juvenile court to the prosecutor. This is called prosecutorial discretion, where they have to give no reason whatsoever. This kid I'm trying as an adult. You see this in the Gina 5 case, where Michael Brown was charged as an adult. You know the Gina 5 case in Gina, Louisiana. We can come back to that in a minute. But he was charged, convicted as an adult, right, for the crime of aggravated assault, and charged with attempted murder. So you have kind of prosecutorial discretion here and accelerated charging. Or you have what we have in Illinois. In Florida has prosecutorial discretion for all juvenile crimes. So a prosecutor anywhere in Florida can decide to try a kid as an adult with no reason given, 13, 14, any age, and any crime. You don't have to show prior record. No showing has to be made, and nobody can overrule it. In my state, in Illinois, we don't do that, but we have a rather equally insidious and highly discriminatory and unequal way of doing it, which is called statutory exclusion. That is to say, there's laws in Illinois that say if you are 15 and 16 and charged with this offense, you must be tried in adult court. And what we found, we tried to challenge the law in 1990, showing that for kids selling convicted of having a certain quantity of drugs within 100 yards of a school, was completely discriminatory because required mandatory transfer. So if you were 15 or 16 in Illinois and you were caught selling drugs within 1,000, did I say yards or feet? 1,000 feet of school, you had to be tried in adult court and subject to mandatory sentencing rules there. We were able to show in 1991 to a judge in juvenile court that this law was only enforced in Illinois. There had never been another single charge anywhere else in Chicago. There had never been a single charge anywhere else in the state. And that there was nowhere in the city of Chicago that you could stand, not a single spot of land, not a single piece of grass, that wasn't within 1,000 feet of a school in Chicago. In the suburbs, there was wide open spaces that were not within 1,000 feet of a school. But they count, for the purposes of this law, colleges and universities and parochial schools and so on. So if you add that all up, there was nowhere in Chicago. And we were able to show that 99% of the kids charged under this law were African American males. Okay? So no white kids charged under this law. And we won a victory from the trial court judge, overturned by the Illinois Supreme Court in 1993, a decision written by the first ever African-American justice of the Illinois Supreme Court. Then we came back and tried to change the law, showing data. We gathered data through the 90s showing that the acceleration of this under this law was just unprecedented. And that nobody in the rest of the state was being mandatorily waived to adult criminal court under this provision, and that it only applied to certain kids in Chicago. Again, we lost several times, and finally, 2 years ago, we were able to pass in the Illinois legislature a law that didn't abolish it, but allowed an adult criminal court judge, on the basis of the facts of the case, to send it back to juvenile court. And so that's what we have right now, something called waiver back in Illinois. But this practice in general of removing a significant number of young offenders from juvenile court protections and jurisdiction, 1 in 6 of all delinquency cases, results in incredibly severe consequences, the rest of your life kind of consequences for kids. One is, if you're tried in adult court, as I said, you're subject to mandatory sentences, and that's almost always much harsher penalties. 2, you will have, by definition, a felony conviction, which is almost impossible to expunge from your record. I don't know what your expungement laws are here. But even if you navigate the impossible maze of expunging your record in Illinois, it will never come off the police data bank computers and all the related law enforcement data bank computers, and probably now the school computers. And so these felony convictions lead, as you know, to massive disenfranchisement, loss of the vote, loss of entitlement to college scholarships, loss of ability to go into the military, or a whole range of job possibilities that have to be licensed by the state, so you can no longer be a barber or a beautician, a whole range of jobs that you can't do if you have a felony conviction. Your housing options are restricted and limited. Third,